All right, party people. This your man Griff. All right, might as well say this part three for the Friday. Um, okay, so we just getting straight into it, talking about the notarial certificates again. Okay, can't say this will be the final time. So to take you back last night doing for the Friday, I talked about a particular notarial certificate that was sent to me. It was actually a document, an affidavit, and it had on there a notarial certificate and very, very odd certificate, very weird. It was not properly formatted. So I was suggesting that based off of what you understand about that document and the fact that they attempted to put in a notarial certificate, you can replace what was there with a jurat. I don't. It was one of the viewers contacted me last night and said that that will be considered an unauthorized practice of law in Florida because I guess they're deeming that as the notary is choosing the certificate to go on the document. I don't agree with that because the certificate has already been identified for what they want on the document. It's just incorrect. So I did a video, part two, explaining a little bit further my my thoughts on that, and I'll link it right over here. Okay, I'll link it right up over there. The second video, um, and you'll see the thing before now for the first one. So the second one, first one, the second one, I'll link all up here in this little area right over here, and you'll see it. And I'll, if you need me, I'll put it also in the description. So what I'm gonna show y'all now is so we can get everybody caught up the document, and then I'm going to go and show y'all what I found out concerning the question about is that the unauthorized practice of law? Okay. Oops. There we go. So this is the document. Okay. It comes starts off telling you it's an affidavit, which I have a drawing tool. Does this thing give you a drawing tool? Nope. All right. So it says affidavit and memorandum of agreement concerning real estate. So it's telling you it's an affidavit. We know that affidavits are sworn statements. So it starts off with the state of county of what that's telling you, okay, somewhere along the line, they're trying to create a notarial certificate. And what I believe they did, which is incorrect, they tried to make it seem like all of this is the notarial certificate, the verbiage that goes in the notarial certificate. That's this here is the agreement. But you can have in some states the state of county of at the top, then the agreement. Oops, sorry, and then the notary area. But even with this, it should be a statement. So let's go back. So right here it says fully sworn. So that tells you it's an affidavit and they've been sworn in. Okay. So the person is attesting that by them signing this, that they were sworn in and they give a deposition or deposes and says that this agreement is that for this place and that it is between this person, the affiant, who is the buyer, and so and so, the seller, on such and such date, all of that. This here is the signature of the seller. This is the signature of the buyer. Now, one of the things that you need to understand, and this can throw people off, this word witness. That is what we legitimately and legally are doing. We're witnessing signatures. That's why I argue so much about stop trying to explain documents because that's not what we're there for. We are there for one thing and one thing only, which is hold on one second, which is to witness the person sign. And then the witness signature, meaning somebody else witnessed this. Then it goes down here and says, this is for the seller side, this is for the affiance, aka buyer, the notary, commission number, and expiration and stamp. So it's clear that this here is their attempt to create a notarial certificate. And we can understand, we can ascertain that it is a jurat. okay? Because jurats are what, or oath to affirmation, depending on the state that you're in, because we can clearly see that that this is for what, the jurat is for affidavits, and on affidavits you get sworn in. So it's, to me, it's clear what the creator of the document wanted. Now, in I won't say changing, in replacing, which is the same thing, in replacing or using the proper notarial certificate, at what point in time is anybody here, the seller or the buyer, asking the notary to choose what certificate goes there? They've already indicated that a certificate needs to be here. And we understand, based off of proper notary, if you've been properly trained or been shown, you should know that an affidavit is sworn in. So that means you need to do an oath and affirmation or a jurat, depending on the state you're in, because that's the two names they're called. So how can you say, well, if I replace the certificate, use the correct certificate, that would be me doing the unauthorized practice of law, because I can't choose it for them. That means they had to ask you whether or not they should use this one or that one. So at what point in time did they ask, meaning these people here or the creators of the document, ask you what certificate should they use? Okay, I hope you're following me. I hope you're following me. So that's where I think people are getting stuck at. Because if you use that logic, what you're saying is that anytime you have to replace a notarial certificate because the one that is there does not meet your state's requirements, you have to ask permission to do that. Now, with general notary work, this really comes into play because there are a lot of documents that people will bring to you and say, "Hey, I got this thing. I got a statement that I got to write. What notarial certificate should I use, or are you going to use?" Then you get into sharing with them the differences and then letting them make the decision for themselves. But you're not advising them of which one to get. You're just making sure they understand the differences, and then they take time in their own mind and say, "I want this one," for whatever reason. And I've been in that situation where people have selected, "Oh, I'll just make it an acknowledgement," when it really should have been a jurat, based off of what the document is and what the purpose and all of that. Okay. And we talk about that in the training, the purposes of these documents. Okay. So I decided, and there was a small dialogue with the gentleman, and I believe it was a gentleman, or like um with the viewer. I meant to say this in the beginning. This is not an attack on anybody. So if you take this personal, that's on you. This is not an attack in any way, shape, or form on anybody. This is not me coming at you. This is not me trying to put you down or come with fire and brimstone or none of that. Okay. This is me trying to get down to the nitty gritty of an answer to a question that is out there, that has been put out there. Okay. So, yes, I'm checking my stuff. I don't know why people get upset with me when I check my stuff, but oh, okay. That might be my FedEx though. I've been waiting on that. All right. So what I decided to do was um take a look, and I called somebody. I called a good friend of mine who's down there in Florida, and we had a discussion about it. I understood their viewpoint. They understood mine. We came to a consensus. I was like, okay, yeah, that makes sense. They said, yep, that makes sense. All right. So the other person apparently, was also in Florida. I don't know. Based off the screen name, I don't know them personally. Okay. So if I do know you, I couldn't tell off the screen name. All right. So what I decided to do when I finally got home after working all over the place today, I had a couple of appointments and house inspections to do. When I came home, I was sitting downstairs. I said, let me get on Gemini and asked it a question. So I said, I need a link to the Florida Notary Handbook. So it gave me a link to the Florida Notary Handbook. I looked at it. I didn't see anything definitively about unauthorized practice of law. So then I asked it, I said, show me the section in the Florida Notary Handbook that explains the unauthorized practice of law. Now, again, I'm just asking a question. If there's a specific area, okay, so don't burn me down because I didn't get it or whatever. So it said there isn't a single Florida Notary Handbook that explicitly has a section titled unauthorized practice of law. Okay, gotcha. The most direct reference is the Florida statute chapters, this, that, and the other, which lists unauthorized practice of law as a specific ground for the governor to suspend a notary's commission. Okay. Furthermore, Florida law makes it a felony for any person not licensed as an attorney to practice law, which means you need to be darn careful when those people out here, them TMCs, telling you what you can do and this, that, and the other. You better make sure that you can. The Florida Bar also provides clear guidance that notaries are not attorneys and are prohibited from giving legal advice. This includes recommending what type of notarization a person needs, preparing or completing legal documents for a client, giving an opinion on the legality or effect of a document. Okay. And then the law requires notaries to advertise their services in a language other than English to include a disclaimer. Oh, it requires notaries who advertise their services in a language other than English to include a disclaimer. I am not an attorney licensed to practice law in the state of Florida, and I may not give legal advice or accept fees for legal advice. All right, cool. So then I asked it, I said, explain and provide examples of this statement for Florida notaries, meaning recommending what type of notarizations a person needs. Then it goes on and explains it. In Florida, a notary public is a public official who serves as an impartial witness. Their role is to verify the identity of the signer and confirm that the person is signing the document willingly. The act of recommending what type of notarization a person needs is considered an unauthorized practice of law. Now, going back to this example, at what point has the signers recommended or asked, I mean, not recommend, but asked what type of notarization needs to go on this document? You are looking at the document and you're realizing that this here notarial certificate is improper. By you putting the proper notarial certificate, that is not you recommending the type of notarization that goes on there, because it's clear, again, it's clear what the intent is. Now, if you want to just say, well, I'm not going to take that chance, that's fine, but it don't mean that what I'm sharing with you and what I understand now is incorrect. So this is where you really got to dig deep if you want to. And I know some of you don't want to. You take the path of least resistance and say, well, we can't do it, and just leave it at that. Because if that's the case, then that means every time you come across something like this, that means you got to call back to the title company and ask them, because asking the signers who didn't create the document what their intent is for this document and what how type of notarization will be fruitless, because they don't know. They're not the ones that created it. All right. So because because the choice of notarization, whether it's an acknowledgement, jury, or other type, depends on the document's legal purpose. That's why I'm saying you go back to who created it. And the specific legal requirements of the transaction. Only a licensed attorney is qualified to provide legal advice on what type of notarization is necessary for a document to be legally valid and effective for its intended purpose. This is the stuff that we learned in the training about the intended purpose of the document. A Florida notary's job is to complete the notarial act that the signer requests, not to advise them on which act to choose. Okay. How must a Florida notary respond? when a signer asks, what kind of notarization do I need for this document? Note what it's saying. When a signer asks, when a signer asks, that's why I said at what point in time did the people ask on this document or any other document? When did they ask? The notary should not provide a direct answer. Instead, the notary should respond with a statement that shifts the responsibility for the decision back to the signer. The proper response should be, I'm a notary public. I am not an attorney. I cannot give legal advice. I am not qualified to tell you what type of notarial act you need on this document. You will need to contact the person who drafted the document, the receiving agency, or an attorney to determine the correct type of notarization. The notary can, however, describe the two most common types of notarizations: an acknowledgement of jurat, and that's what it says right here. An acknowledgement verifies the person voluntarily signs the document. Jurat signs, the signer takes an oath or affirmation swearing or affirming that the statements in the document are true. That's what I was saying earlier. Okay, I need to zoom that in a little bit more. That's what I was saying earlier. Okay. And in the correct scenario, then it gives scenarios and all of that, the improper way and all of that. Okay. So I asked the question, I asked it this question. I said, okay, if a Florida notary sees an improper notary certificate on an affidavit, meaning that the jurat certificate does not have the requirement elements for Florida, would it be considered the unauthorized practice of law if a Florida notary uses the correct notarial certificate either by adding a separate jurat or handwriting in the missing elements on the existing jurat? And they came back and said, no, it would not be considered the unauthorized practice of law for a Florida notary to correct an improper or incomplete notarial certificate. And that was the mistake that I made in talking about this last night. I didn't describe this as an incomplete notarial certificate, but it is incomplete because it does not have the necessary elements that I know my state of Virginia would want. And it's clear probably for anybody's state. Okay. As long as it's done correctly and in the presence of the signer. In this scenario, the notary is not giving legal advice, but instead correcting a notarial error, which is within the scope of their duties. This is why you need to stop worrying about marketing and all of the little super cool fancy stuff and make sure you understand the scope of your duties. That's what you need to make sure you understand because they're not teaching you this. The notary certificate is their statement of the facts of the notarial act they perform. It is there talking about the notary's responsibility to ensure that the statement is accurate and complete according to Florida law. How to correct an improper certificate. When a Florida notary identifies an improper jurat on an affidavit, they have two primary options, but both require the signer to be physically present. Attach a separate loose certificate. This is the most common and recommended practice. A notary should draw a single clean line through the incorrect pre-printed certificate. Now, the only caveat that I have with that, let me come back to y'all. The only caveat that I have with that is sometimes the receiver of said document may not want that. Okay. Unless it's specific in your state law. So that's the one thing that I didn't ask Gemini to tell me where in the state law does it says to draw a single line through the incorrect pre-printed certificate. Okay. Now, if you do it, fine. If you don't, I'll have to say fine because some entities don't want that on the document. They just want you to add the proper certificate, loose certificate, and call it a day. All right. So the notary should then write see attached jurat and initial and change and the date the changed. Okay. I get it. You just have to make sure that one, this is what your state law says you have to do, and two, make sure that if it doesn't say you have to do that, then make sure that the people who are receiving the documents are okay with you doing that. And if they're not, then make note of it in there or just don't do the notarization. The notary will then attach a new correct jurat certificate that has all the required elements for the oath or affirmation in Florida. The new certificate is then completed with the signer's information and signed and sealed by the notary. They don't sign the certificate, you do. Handwriting the missing elements, you can do that. Now, here's the key. Why is this not unauthorized practice for law? The key, yeah, I think that's big enough. The key distinction is that the notary is not advising the signer on what kind of notarization they need. You need a jurat for this affidavit. You're not doing that. Instead, they are recognizing that the document already has a notarial certificate attached, even if it's flawed, and their duty, talking about the notary, is to ensure the certificate for the act they are performing is correct. By completing or correcting the certificate, the notary is fully fulfilling their responsibility as a public official to accurately and fully record the details of the notarial act. The legal determination was made by the document author or signer. The notary's job is simply to execute the requested act and certify it properly. That's what our job is. That's what we're doing. And I'm glad I looked into this. And again, I thank that person for asking that question because it led me down a little bit of a rabbit hole to articulate, because that's in a sense what I was trying to say. I just didn't do a great job. I didn't do a good job at it at all. But that's the thing. Our job is to make sure that this is properly notarized, the signature, which means we're responsible for the notarial certificate. That's really what it boils down to. Now, you tell me what your thoughts are. Now, I already know some of you gonna be like, bump all that, Griff. I'm cool. You do you. But as a business owner, it's your responsibility to look into these details, because if you're getting your advice just from the NNA and the NNA is saying, well, best practice for the NNA means what? It may not be legit. It may just, that's just what they think you should do, but there's no legal precedence for that. Okay. That's what you need to do. Let me ask you that question. Let me ask. I don't forget the question I was gonna ask you. I'll probably ask you later. I don't forget the question that quick. Oh man, I'll go back to it. I'll look at the video and I'll go back later. All right, so let me get out of here. All right, let me get out of here. Oh, there it is. Okay. And this is how I like to do it so y'all can see me asking the question. Okay, where in the Florida notary statutes does it say when a notary public is using a loose certificate for the notary to draw a single clean line through the incorrect pre-printed certificate and to write see attach. I forgot the initial date. So let's see what it says. Boom. Oh my goodness, boy. Don't tell me I don't know what I'm talking about. Right here. Look, this specific procedure, draw a line through an incorrect certificate and write see attaches a widely accepted best practice in the notary industry, recommended by organizations like what? The National Notary Association. See, y'all think I don't be knowing what the heck I'm talking about. Whenever the NNA, now I just did this. I did not do this prior to everything else that you saw. I had already typed up in there and read through. This was fresh. That's why I made sure y'all saw this. I didn't know what was coming up. I didn't use a different Gemini, prompt, all of that. Okay. It goes on and says, it is not directly stated in the Florida statutes. The statute outlines the legal requirements for a valid notarial act, such as require elements for a jurat or an acknowledgement, but they do not provide a step-by-step procedural instructions on handling common errors. The reason this practice is so strongly recommended is that it maintains the integrity of the document. By avoiding the original certificate, it prevents any potential of fraudulent party to separate the documents, dot, dot, dot. Got it? Creates a clear record. And I'm not disagreeing with that. I'm just saying you need to find out whether your state wants you to do that. The notation see attached directs any future parties to examine the document to look basically to the correct notarial information. While Florida does not contain specific language, the overall framework of notary law requires notaries to act in care and perform their duties accurately. This procedural step is one way of fulfilling that responsibility. Come on now. Y'all just learned something here. Again, you got to be open-minded. I'm open-minded. I'm willing to learn and go out here and research. I don't just take it as face value. Just because the NNA said it, don't mean it's true. Okay? Just because your TMC said it, don't mean it's true. Don't mean that what I'm saying is true. That's why I show y'all. I do the research out here. You get to see how I ask the question. And again, I know some people, well, AI is wrong. AI could be lying to you, Griff. Got it. But take what you just saw and go present it to your attorney that you have with Legal Shield and ask them. Ask them, is this correct? You don't have to take my word for it, but you got to get the correct word. You don't have to take my word for it, but you do have to get the correct word if you plan on running any business. Now, if you don't want to take my word, then why are you taking other people's word without doing any research? Well, they said it. Okay, I'm going to do it. It makes sense. What makes it make sense? What makes what I'm sharing that I'm showing you proof of not make sense? That's the question. Okay, that's the question. So we clearly see that it's not in state statute at all. Matter of fact, I'll ask it this question, then we out of here. Okay. Does any state recommend recommend that notaries make that type of correction to an improper notary certificate? Does any state? Yeah. All right. I probably could have been a little bit more descriptive in that. All right. So here we go. California requires notaries to use specific wording, dot, dot, dot. Okay. Okay, make a note. So right now okay, wow. Okay, going up there, how to fix the notary error. Okay. So California requires notaries to use specific wording and acknowledge jury if the document has pre-printed certificate that does not match. The notary must attach a separate loose compliance certificate. But then it says The National Notarization advises notaries to strike through and prevent it. Okay. The Pennsylvania law, Rolona, which governs the state, the notaries requires a certificate for a notary act. Using a loose certificate is a standard procedure when there's notarial wording on the document or the pre-printed wording does not comply with state law. The notary is expected to make a note on the document that the loose certificate has been attached. So even with that, it does not say you're supposed to line through with either one of them. Let me zoom this in so y'all can see it. So neither one of these from Pennsylvania or California specifically says that. The only place that says it is the NNA. And I'm not saying you can't do what they're saying. You just need to understand where your guidance is coming from. Where your guidance is coming from. That's what you need to know. You need to understand that is coming from over here. It's not coming from my state. And the reason why this is important is because there was a gentleman that's one of my channel members. He had a situation where a particular title company, I'm not going to say the title company's name here, but a particular title company, big title company, that actually that gave him a document that was a deed, some kind of deed thingy, and all it had was the signer's name, and they wanted him to notarize it. It had no information filled out about the property that it was for, no pricing, no nothing. It had nothing on there. It just had a spot for her to sign and for him to notarize. He said, I can't do it. And you know what they said? Where does it say that in your state law? So if you're saying I can't do this and they're saying yes, you can because it doesn't outline that in your state law, this is why it's important for you to understand where the advice that you're getting is coming from. If the advice is coming from the NNA and that company does not recognize the NNA as the authority, they recognize your state law. They look in your state law. There's nothing in your state law said that you need to be lining through and initialing and dating and all of that. So we prefer you not to do it. You go back to what the NNA say, they go back to what your state law says. They're the one that's paying you, not the NNA. And you have no evidentiary proof that supports what the NNA says that you should do, and they deem it as best practices, not notarial law for your state. This is how you can look like a fool out there because they're sitting up here saying, we're going by what your state law says. Your state law, dot, dot, dot. That's why this is important. Okay. That is why this is important. And he went to them and told them, hey, I can't do this. They said other notaries do it. And he refused to do it. They didn't want to pay him. No, they didn't pay him or anything. And then they told him, we're not going to use you anymore. So any orders that he was getting, and that really affected him financially. But he stood on business and said, hey, look, I can't do that. And I'm very proud of him. I'm very proud of him. And he's going to be all right. But this is what we're faced with. So when you sit up here and say, oh, we can't do this and we can't do that and we must not and we shall not and all that, based off of what? Is it based off of what somebody told you? Is it based off of what you actually went out there, researched and learned? What is it based on? And too many human beings hear some things that sound cute, but they refuse to actually get the truth of the matter. They refuse it. They like, nah, I ain't got, no. Well, look, all I know is what, well, why would they lie? It's not that somebody's intentionally lying to you. It's just that they don't know the truth. So they're misguiding you. So why accept them? Go find out for yourself. And this is to everybody. Again, this is not attacking any person who asks a question or whatever. So please do not take me responding back or any of that as me attacking you or putting you down or thinking that you're being disrespectful to me. No, I get it. We're dialoguing. And I love this. I really, really, really do. Not because it's to prove me right, but it's to get to the truth of the matter. And many of you who've been rocking with me, that's what I always say. Let's get to the truth of the matter. If what I'm saying is incorrect, question it, throw a comment, have your sources. Let's investigate it. Let's come up with the truth. And then we all are right. And then we're all out here doing things good. That's what this is all about. So I hope y'all enjoyed yourselves. Hope you learned something. I don't know if there's going to be a part 4, but I like what we got going on so far. Give me your thoughts in the comment section. Talk to you later. Peace.